Have you ever sat at work and wondered, what rights do I actually have as an employee in the United States? You're not alone. Every day, millions of workers face tough questions. Can your boss fire you without cause? Should you get paid for overtime? What if you're discriminated against or treated unfairly? The truth is, federal labor laws give you specific protections, and knowing them can make the difference between being taken advantage of and standing up for yourself. In this video, we're going to break down 5 of the most important rights every American worker should know. I'll keep it simple, practical, and backed by real law, not rumors, not workplace myths. So before we dive in, take a second to hit the subscribe button and turn on notifications. That way you'll never miss an update that could protect your job, your paycheck, and your peace of mind. Let's get started. Minimum wage and overtime, FLSA. One of the very first rights you have as a worker in the U.S. comes from the Fair Labor Standards Act, or FLSA, which was passed in 1938. This law set the foundation for minimum wage, overtime, and child labor protections. Let's start with minimum wage. The federal minimum wage today is $7.25 per hour. That's the floor. But here's where it gets interesting. Many states and even some cities set their own minimum wages, and those are often higher. For example, California's statewide minimum is over $16 per hour. In Seattle, it's more than $18. Under the law, if state or local law sets a higher minimum, your employer has to follow that higher standard. So if you live in California, you're not stuck at $7.25. You get the California rate. Now, let's talk overtime. The FLSA says that if you are a non-exempt employee, you must be paid time and a half for all hours worked over 40 in a work week. Let's say you normally make $20 per hour. If you work 45 hours, the first 40 hours are at $20, and the extra 5 hours must be paid at $30 each. That's the law. Here's the tricky part. Not every employee qualifies for overtime. If you are classified as exempt, meaning you're in certain executive, administrative, or professional positions, and you're paid a salary above a certain threshold, your employer might not have to pay overtime. But misclassification is common. Employers sometimes call workers managers or salaried when their duties don't actually meet the exemption test. If you spend your time stocking shelves or running a cash register, calling you a manager doesn't erase your right to overtime. The U.S. Department of Labor enforces the FLSA. Workers can file complaints if they believe they're underpaid or denied overtime. In fact, wage and hour lawsuits are some of the most common employment cases in America today. So, remember, if you're working hard, you deserve at least the legal minimum wage and overtime pay if you qualify. That's your right under the FLSA. Protection against discrimination, Title VII, ADA, ADEA. Another core protection is the right to a workplace free from discrimination. This is guaranteed by a group of federal laws, starting with Title VII of the Civil Rights Act of 1964. Title VII makes it illegal for employers to discriminate based on race, color, religion, sex, or national origin. Discrimination can happen in hiring, firing, promotions, pay, or any other term of employment. For example, if 2 equally qualified people apply for a job and the employer refuses to hire someone because of their religion or gender, that's unlawful. It doesn't stop there. The Age Discrimination in Employment Act, ADEA, protects workers who are 40 or older from being pushed out or denied opportunities simply because of age. And the Americans with Disabilities Act, ADA, requires employers to provide reasonable accommodations to workers with disabilities, like adjusting schedules, providing assistive technology, or modifying duties, unless doing so would cause the business significant difficulty or expense. Harassment also falls under these protections. Sexual harassment, offensive jokes, slurs, or repeated unwelcome behavior tied to a protected characteristic can create a hostile work environment. Employers are legally obligated to address these issues once they're aware of them. And here's a critical point. Retaliation is illegal. If you file a complaint with HR or the Equal Employment Opportunity Commission, EEOC, and then suddenly get your hours cut, are passed over for promotions, or even fired, that's retaliation, and it's against the law. In fact, retaliation is one of the most common charges the EECC investigates. Let's put this in perspective. In 2022, the EEOC received over 70,000 workplace discrimination charges. Many resulted in settlements, reinstatements, or financial compensation for employees. These laws aren't just words on paper, they are enforced every day. So, if you ever feel you're being treated unfairly because of your identity, your age, or a disability, know that federal law has your back. Workplace safety, OSHA. Beyond pay and equal treatment, you also have the right to a safe workplace. This is covered by the Occupational Safety and Health Act of 1970, commonly called OSHA. OSHA requires employers to provide a workplace free from recognized hazards that could cause serious injury or death. That covers everything from unsafe machinery to exposure to toxic chemicals, from fall hazards on construction sites to fire safety in warehouses. Let's say you work in a factory where protective equipment isn't provided or chemical labels are missing. That's a violation. Or maybe you're in a warehouse where forklifts are being driven recklessly and no training is given. Again, that's a violation. Here's what you should know. Workers have the right to file complaints with OSHA. Inspections can follow, and if violations are confirmed, employers can face heavy fines. And, importantly, you cannot be fired or punished for reporting safety concerns. That's called whistleblower protection. Workplace injuries are another area of protection. Most states require employers to carry workers' compensation insurance, which provides medical treatment, wage replacement, and sometimes rehabilitation if you're injured on the job. Unlike a personal injury lawsuit, you don't have to prove your employer was negligent. You only need to show the injury was work-related. This matters because every year, millions of workers get hurt on the job. Construction workers fall from scaffolding, warehouse employees strain their backs, and healthcare workers suffer needle sticks. OSHA and workers' comp laws exist so you don't have to carry those burdens alone. Bottom line, no paycheck is worth your health or safety. If your job is unsafe, the law says your employer must fix it, and you have the right to speak up. Family and medical leave, FMLA. Life doesn't stop when you clock in. Sometimes you or your loved ones face serious health challenges. That's why the Family and Medical Leave Act, FMLA, was passed in 1993. Under FMLA, eligible employees are entitled to up to 12 weeks of unpaid job-protected leave in a 12-month period. What does that mean? It means you can step away from work for certain serious reasons without fear of losing your job. The law covers caring for your own serious health condition, caring for a spouse, child, or parent with a serious health condition, welcoming a new child through birth, adoption, or foster care, certain military family situations. To qualify, you need to have worked at least 1,250 hours over the past 12 months, and your employer must have at least 50 employees within a 75-mile radius. Here's the key. When your leave is over, your employer must restore you to the same job or one that is nearly identical in pay, benefits, and responsibilities. They can't demote you or punish you for taking leave you're legally entitled to. Now, FMLA is unpaid at the federal level, but some states, like California, New Jersey, and New York, have their own paid family leave programs. These provide partial wage replacement while you're out. It's worth checking your state's laws because benefits vary widely. Remember, family and health come first. FMLA exists so you don't have to choose between caring for loved ones and keeping your job. Right to organize, NLRA. Finally, let's talk about your right to stand together with coworkers. This is protected by the National Labor Relations Act, NLRA, first passed in 1935. The NLRA gives employees the right to form, join, or assist labor unions, and to engage in concerted activities to improve wages, benefits, or working conditions. That means even if you're not in a union, you and your coworkers have the right to act together to demand change. For example, if a group of employees signs a petition asking management for safer equipment, or if workers walk out together over unfair scheduling practices, those are protected activities. The employer cannot legally fire or discipline workers for this. The National Labor Relations Board, NLRB, enforces these rights. If an employer retaliates, the NLRB can order reinstatement with back pay. This law is especially relevant today with headlines about workers at companies like Starbucks and Amazon voting on union representation. Regardless of where you stand, the right to organize and negotiate collectively is protected by federal law. It's important to note, supervisors and certain categories of workers may not be covered, but for millions of private sector employees, the NLRA is the backbone of workplace organizing rights. So, if you and your coworkers are trying to improve conditions, know that you have the law on your side. Let's recap. As an employee in the United States, you have the right to a fair minimum wage and overtime pay under the FLSA, protection from discrimination and harassment under Title VII, ADA, and ADEA, a safe and healthy workplace under OSHA, time off for family or medical reasons under the FMLA, and the right to organize and act collectively under the NLRA. These rights exist to protect you, but they only matter if you know them and use them. If this video helped you understand your workplace rights, do me a favor, hit like, subscribe, and share it with someone who needs this information. And if you have questions about your own situation, drop them in the comments. I'll be covering more workplace law topics in upcoming videos. Remember, knowing your rights is the first step to protecting them.